Welcome everyone to Understanding the Basics of Grain Dealer Statutes. My name is Audry Thompson, and I'm a staff attorney here with the Penn State Center for Agricultural and Shale Law. Next slide, please. The Understanding Agricultural Law educational series is a course designed to provide subject matter literacy and competence on fundamental issues of agricultural law to attorneys and business advisors who work with or represent agricultural or rural clients, but who may not necessarily specialize in agricultural law. This series is sponsored by the Pennsylvania Department of Agriculture's Ag Business Development Center, established in the 2019 Pennsylvania Farm Bill. The Agricultural Business Development Center aims to enhance the long-term vitality of Pennsylvania farms by supporting farm transitions, both from generation to generation and from conventional to organic farming, supporting beginning farmers, providing risk management education, and providing financial assistance through low-interest loans and grants. Next slide, please. We have covered numerous topics in the Understanding Agricultural Law education program. This is just a small sampling here, including ag labor, finance, conservation programs, Pennsylvania's clean and green, water issues, many, many more. You can find materials and recordings from all of these programs on our landing page at aglaw.psu, and that is also in the chat here, and I'll be putting it in one more time, actually many more times. Next slide, please. We encourage you to mark your calendars and register for our upcoming programs under this Understanding Agricultural Law heading here. On October 31st, any of our repeat attendees may know that we've done a switch around here. October 31st, we are going to have a guest speaker, Jacob Monty from Monty and Ramirez LLP in Texas, talk about immigration compliance, I-9s, audits, and ICE raids. That's going to be an excellent program. Recommend you get registered for that. Then November 21st, that'll be cell-cultured foods and labeling laws. December 12th will be Clean Water Act, biosolids and food processing, waste land application. And then in January, we will talk about the Pennsylvania Seasonal Farm Labor Law. Those are all at noon Eastern Time. Pennsylvania Attorney CLE is available for each program, and you can register on our landing page. Next slide, please. Then we've got our quarterly dairy legal webinar series. Our next webinar under that program will be here in a couple weeks on October, that's not right, it should be October 14th. Should be October 14th, sorry. Third quarter of 2025, it's correct in the events. That'll be dairy provisions in the reconciliation bill, HR 1, or the One Big Beautiful Bill. Then Tuesday, January 23rd, we'll cover the fourth quarter of 2025, and we are thinking our focus topic will be standards of identity for dairy, but we're still hammering that out. Both of those programs also at noon Eastern Time, Pennsylvania Attorney CLE also available. Next slide, please. And we are excited to announce that we have teamed up with Penn State Extension to offer education and services through the AgWorks program, which is funded 100% with federal funds from the U.S. Department of Labor for a grant totaling $1.3 million in 0% non-federal funds. This two-year program aims to link agribusinesses to workforce services, educate workforce professionals about the needs of agribusinesses, provide services and training to individual agribusinesses based on needs, and help small agribusinesses grow and succeed. AgWorks will provide 100 registered small to medium-sized Pennsylvania farms and agribusinesses with no-cost training and consultation to ensure business sustainability in the areas of hiring and retention, business operations, compensation and benefits, legal counseling, that's where we'll come in, health and safety, and PA career link services. The program aims to register 1,000 agribusinesses in the PA career link online system. If you are watching this webinar and you know a PA farm that would benefit from this program, or you a PA producer who would benefit from this program, please check out the links there in the chat. You can send referrals or questions to agworks@psu.edu. And the first webinars that the center is going to provide have been scheduled starting next Tuesday with the basics of fundamental employment fundamentals there, I believe, on September, foundations of employer-employee relationship, September 30th. Anyone can register for those, but I will let you know Attorney CLE is not available. But if you have a producer you're working with and you feel like this would be a good program for them, please refer this, have them fill out the forms. That would be wonderful. Next slide, please. And one last plug, we are honored to co-sponsor the Mid-Atlantic Ag and Resource Law Conference alongside 8 fine other institutions listed here. That's going to be October 28th and 29th in Shepherdstown, West Virginia. 7 Attorney CLE's credits will be available for that. And the program is not listed there, but I will tell you we've got land use challenges and opportunities for ag, solar siting in Virginia and West Virginia, legal strategies for addressing risks of losing family farmland, conservation easements, navigating heirs property in practice, how to handle a zoning hearing and ethical use of generative AI for lawyers. So that is available on our events page. You can register for that or learn more about that if you are interested. And finally, one last piece of information before we get started here. Let's see, this webinar is being recorded. If you have any questions, please write them down in the Q&A feature and I will collect them and ask them at the end. We encourage you to fill out the poll at the end of the webinar. Won't forget this time. Tell us what you liked, where we can improve, and what topics you'd like to see in the future. And if you're interested in CLEs, there is a CLE form. They're listed in the chat. It's also linked on the materials page. You must be registered to get CLE for this program. You need to fill out that form to get CLE for this program. And there will also be a code word later in the webinar that you need to put in that CLE form in order to get your credit. We can send you an attendance certificate if you are out of state. So let us know. There's a place for that in the form as well. And if you're calling or some reason you need an email, you can email me at aet17@psu.edu. That's Alpha Echo Tango 17@psu.edu. All right, I will now turn this webinar over. Ross Pifer serves as the director for the Center for Agricultural and Shale Law and is a clinical professor of law at the Penn State Dickinson Law, where he teaches property, oil and gas law, agricultural law, and coordinates the Rural Economic Development Clinic. Russ, the screen is all yours.
Thank you, Audrey. And just to follow up on Audrey on the Ag Works program that we are next week, we'll be starting the webinars for that. You may see a little bit of what appears to be overlap between this series, the Understanding Agricultural Law series, and the Ag Works series. However, keep in mind, as Audrey mentioned, you're getting CLE for this program, or Pennsylvania attorneys can get CLE for the Understanding Agricultural Law program. AgWorks, there is no CLE available, as the focus for that for the audience, the focused audience for those programs are producers, and we certainly welcome everyone to participate in all of our programs, but the focus for the AgWorks programs is on producers, and so we don't offer the CLE credits. Okay, so today I want to talk about state grain dealer statutes in the United States. And frequently when you hear about these grain dealer statutes is when there's been some kind of failure. And frequently when a grain dealer doesn't pay a farmer for the commodities, it's not just one farmer that isn't getting paid. It's many farmers who aren't getting paid. And so there is the potential, as this one headline, the second headline on the right column, that talks about the pay woes for grain growing tendrils, where you have these this cascading effect of a farmer not getting paid and many farmers not getting paid, and how that can impact other sectors of the or other parts of the ag business community as well. And on the right hand side, the top headline, a situation that was pretty close to home when we had a failure to pay by dealers a few years ago. So today we're going to talk about grain dealer statutes, and I'm going to start by highlighting a couple references that I think if you want more information, or you want to flag these for the future, if this issue comes up and you want information, I want to touch on some of these resources right at the outset. I then want to just say a couple words about the distinction between grain dealers and grain warehouses, because I think you have to keep that distinction in mind. Then I want to talk a little bit about the types of grain dealer statutes, and then we're gonna walk through the typical provisions that you see in grain dealer statutes. Okay, so just to highlight the resources at the outset, the National Agricultural Law Center, which of course is a great resource on many topics, and really is should be one of the first sites that you look at when you're researching an ag law topic. They have some good resources on grain dealer statutes. Here is kind of their their main page, their lead page on regulation of grain sales and storage. So I'd encourage you to take a look at the resources that they have. And then on our website, this is a screenshot of what we're calling Grain Dealers Regulatory Compilation, where we have a lot of information about these statutes, about the content of the provisions that are in these state statutes. So I would, these I think are the two places that I would encourage you to start your research on this topic. Okay, so now grain dealers versus grain warehouses. I think it's important to recognize the distinction between these two entities, because they frequently are regulated somewhat differently. The state statutes will define what is the entity that is regulated by the statute. Some states will have separate statutes for grain dealers versus grain warehouses. Some of them will have provisions that apply to both of them. And I think when you think about what the difference is between a grain dealer and a grain warehouse, it certainly makes sense to at least consider how they should be treated differently. And a grain dealer is an entity that is actually purchasing the grain. So title is transferring from the farmer to the business, to the grain dealer, so that at the end of that transaction, the grain dealer actually owns the grain, and the farmer should have the funds from that transaction. That contrasts with a grain warehouse, which generally is not taking title. They are providing a service for the grower, the service being storage of the grain. And so, there certainly is a risk from the farmer's standpoint, there's a risk of not being paid or losing your grain without being paid, but they are different legal arrangements, and so it frequently necessitates some different treatment for the grain dealers or the grain warehouses. Okay, so just to put this topic of grain sales and storage in context, we are largely talking about a small number of commodities, and what happens when payment is not made for those commodities. And most of these statutes are providing for bonding, or the statutes that I'm going to talk about here in a few minutes are providing for bonding or indemnity, something that provides a safety mechanism for producers to be paid when the buyer has defaulted. And there certainly are other statutes at the federal and at the state level that can provide similar protection for other commodities. So, in Pennsylvania, for example, we have these requirements applying to milk dealers. At the federal level, some of you may be familiar with the Packers and Stockyards Act, or the Perishable Agricultural Commodities Act, and these two, long time federal statutes provide mechanisms through statutory trust provisions to provide some level of protection for producers when the buyer defaults. So we're talking, just to kind of put this in the big picture, we're talking about specific statutes that are dealing with specific commodities at the state level. Now, about a year and a half ago, in this Understanding Agricultural Law series, we provided a webinar that was entitled Understanding the Basics of Producer Protections for Buyer Default. And this webinar today really is a follow-up from that webinar. That webinar touched on grain dealer statutes. It touched on the Packers and Stockyards Act, Perishable Agricultural Commodities Act, talked about Pennsylvania milk dealer bonding as well. So if you're interested in a bigger picture on this topic, I would encourage you to go to our website and look at that recording, or take a look at the PowerPoint or other resources from that webinar. Okay, so why should we regulate grain dealers in this respect? Why do we care? And I think at the kind of the most basic level, we want to make sure that growers are paid. We want to minimize the impact of a dealer failure. So as you look at these provisions that I'm going to talk about and think about what is what ultimately is happening from these provisions, it's trying to minimize the ripples that occur when you have a dealer failure. So maybe there are some growers who maybe there are procedures in place to protect those growers, but also to try to limit the impact. And some of the provisions such as the licensing provisions, the prompt payment, and other actors, they provide a bit of a barrier that either can keep actors out of the industry, or make sure that if they aren't complying with these requirements, that they're not going to stay in the industry very, very long. And so that serves to minimize the impacts, the ripples, the tendrils, as that earlier article headline that I mentioned made reference to. And I think ultimately, by doing everything listed above, you're going to have stability in that, or you're going to have more stability in that commodity market, which benefits all of the players in the market. It benefits the producers and ultimately the consumers and other dealers, and by having that stability. Okay, so how do states do that? And we're going to talk about the types of provisions that are in these statutes. But before we do that, I think two questions that are kind of foundational questions before you get to the provisions are: one, who are the dealers or warehouses? What are the entities or the actors that are regulated, and what's the scope of the commodity that is being regulated? And when you look at that second question, the scope of the commodity, the various statutes kind of fall into different buckets, if you will. So you have, kind of what I'm referring to as a traditional grain dealer statute, which is a statute that is dealing with corn and soybeans and wheat, kind of the classic commodity grains. Then you will have some statutes that will expand that universe just a little bit by maybe adding some other commodities. So the core of those statutes still are on those core commodities, but they're a little bit broader. And then you'll have states who have a statute that is even broader, that covers a whole variety of agricultural commodities. Grain are just one or a few of those agricultural commodities that are being included. So so states, they're focusing on maybe more narrowly on commodities, or maybe more broadly on general agricultural commodities or crops. And then there are states that have no statute, and Pennsylvania is one of the about 10 states that do not have a statute in this area. As we look at kind of Pennsylvania's neighbors, I think it gives a good illustration of what the coverage is in these various state statutes. So I'm just going to kind of go clockwise around Pennsylvania, looking at our neighboring states and seeing, specifically focusing on what are the crops or the commodities that are addressed in there. I have grain dealers in quotes because as we'll see, some of these statutes really aren't regulating grain dealers. They're regulating agricultural more broadly. So starting with Ohio and just kind of working our way clockwise around Pennsylvania, you'll see that Ohio is one of those more traditional grain dealer statutes where it is addressing corn, soybeans, wheat, and it does open the door for a broader range of crops if the state director of agriculture designates some. But this statute is very much focused on the traditional grain crops. We get to New York and we see a different approach. We see that grains are included, but so is a lot more. And so you have a whole range of agricultural products that are being addressed. New Jersey, kind of somewhat similar in that it mentions grain, but includes that within a broader set of agricultural commodities. Look at Delaware, and this really isn't a grain dealer statute at all. I mean, Delaware's statute that is really, it looks like it's covering the same scope as what the federal Perishable Agricultural Commodities Act is, where it's addressing fruits and vegetables. So just highlighting Delaware as an example of a kind of a similar statute that's addressing agricultural crops, but not addressing grain or not mentioning grain in any respect. Then you have Maryland and a more traditional grain. The scope covers more traditional grain crops of corn, wheat, rye, oats, barley, sorghum, soybeans, and adds sunflowers into that as well. And then you have West Virginia, which again is very broad to include agricultural products, but mentions grain. So if you look at those six states around Pennsylvania, you have Maryland and Ohio that are more of the traditional grain dealer statutes, or a grain dealer plus or grain plus statute. You have West Virginia, New York, New Jersey, which are really covering broader agricultural commodities, including grains, and then you have Delaware, which is specifically focused on fruits and vegetables. Okay, so now let's get into some of the specific provisions or the types of requirements that these statutes have. And we have this, I've broken this down into 8 categories, which I'm going to run through. And if you look at the resources on our website, it's going to track these categories. So let's talk about licensing. And this is a requirement that's in more than 30 states. And as we walk through these different types of requirements, you'll see that I'm really using 2 standards. I'm saying, or 2 thresholds. I'm either saying 30 plus states or I'm saying 10 plus states. And I don't really want to get into get into the weeds enough to say, well, it's 37 states, 38 states, or 33 states, because ultimately I don't think that's relevant. But what I do think is relevant is that if I'm saying that licensing is required in 30 plus states, that is just about every state that has one of these statutes has this requirement. Whenever I get to those requirements and I'm saying 10 plus states, I'm saying some states have this requirement, not the majority, not all, but I guess what you could say is a significant minority of jurisdictions have that requirement. But with licensing, it is fairly universal, that these statutes have a licensing requirement. So an individual or entity who is going to conduct business of the covered commodity has to get a license. There are some states that accept cash buyers, cash meaning immediate payment. Sometimes cash, there's a certain number of days kind of grace period and someone is still considered a cash buyer. But here we're talking about immediate payment, who are not required to get a license. And if you think about it, that makes sense. If the point of this is to try to protect against buyers who are not paying, if you have a cash buyer who is paying, we don't have that concern. So the application process, typically you have financial statements. Normally, it's required that they are prepared by a certified accountant. There are a couple states that have a criminal background check, but for the most part, it is open to anyone to apply for a license, and then typically that license is renewed annually, either on a based on the day of issuance. Some states have a calendar year, so you get licensed for a particular calendar year. Some states allow for a longer term renewal. Some states have have a very limited or no review based on the renewal. Some states require a more extensive review or inspection before there is renewal. The fee is sometimes a fixed amount. Sometimes it's based on volume. And once the license is granted, there is generally some type of posting requirement, so that members of the public, who wished, or it's available so that members of the public could easily see that this facility is licensed. And as you think about the nature of some of these businesses, they might not have a fixed location. They may be more mobile, and so though that license may need to be posted in those in vehicles or other kind of mobile locations. And I mentioned here California. There's a requirement that the directors have a card that is showing that license. Okay, so what can cause a license to be denied, an application to be denied, or a request for renewal to be denied, or for the license to be suspended? The statute is gonna list out all of those circumstances. These are some of the common circumstances: violating the statute of reg, false or misleading statements, refusing to allow inspection or audit or show financial records, failure to provide bonds. And some of them, if you have a license in multiple states and you get a license revoked in one state, the license is also revoked in that home state. And you think about, again, going back to the article headline that I mentioned earlier, talking about the tendrils of a non-payment. If you have a dealer who is not making payments in one state, are those dominoes going to fall into another state? And it certainly is very foreseeable that the dominoes are going to have an impact in another state. And so some statutes recognize that and provide for a suspension under those circumstances. Where there is a denial or suspension, typically there is a notice that is provided, a hearing that is either automatically scheduled or can be requested, and sometimes there are administrative appeal rights that are provided within this process. Okay, now moving on to the next type of requirement, auditing. This also is a provision that is generally provided for in these statutes. And there is, all of the states, or virtually all of the states, are going to have some type of requirement to retain records that provide information on sale. Who did they purchase the grain, or who did they purchase the grain from? What was the date of the transaction, the condition, how much was paid? The states vary quite a bit in terms of the retention period, from a low of 1 year up to 6 years. Some states don't have any defined years. They just leave it to what is a reasonable time period, without specifically having a defined number of years. With regard to auditing, most states do allow for an audit to take place at any time, or an investigation. Some of them, if there is a complaint, then an audit or an investigation can occur at that time. And there are some that have annual audits or inspections that are part of that renewal process. Statutes are sometimes fairly specific in terms of what has to be provided in these inspections in terms of books and the records, and not complying with the request generally is something that can cause the license revocation or a fairly significant fine. Okay, prompt payment. So this is a requirement in a minority of these statutes, and I have the question of why don't most statutes contain it, or why don't most contain it, and I don't know the answer to that. Prompt payment is kind of a central part of the framework in the federal statutes, the Packers and Stockyards Act and the Perishable Agricultural Commodities Act. And I guess the idea of having a prompt payment is it helps to minimize the time lag in the payments. And if you think about what is the typical behavior or actions that are going to happen when a dealer is not making payments, they're going to stretch those payments out. So maybe they were paying at 10 days, now it's 15 days, now it's 30 days, and as that payment lag stretches out, there are more farmers that are owed money. And so when the house of cards eventually collapses, more people are going to be affected. And so I think the states that have this prompt payment requirement are really minimizing how big that house of cards is going to get. Time of payment, contract is going to govern. If the contract is silent, then again, prompt payment varies on the state statutes from 10 days to 6 months. I'm not sure why 6 months is really, it doesn't sound very prompt to me, but that is the range of time that these statutes will have, and most of them don't specify a particular manner of payment. So it can be check, electronic transfer, cash, or cashier's checks, or really any way. Okay, again, another minority of states have provisions that specifically deal with when a dealer has not paid, what steps are going to be taken kind of at a larger scale with regard to that dealer. And so the states that have these provisions will generally provide that when they become aware of when the regulatory agency becomes aware of insolvency, the board is going to appoint a receiver or a trustee to handle those assets through judicial proceedings. Most states will provide for a seizure of assets, and so this is not bankruptcy, but again, these are state statutes, so these are state procedures. But you could see there's likely to be some overlap or some interplay between bankruptcy proceedings in many of these actions. When liquidation occurs pursuant to these statutes, you're going to have notice to claimants before the liquidation begins. You're going to have, there may be notices provided at other stages of the processes as well, and typically those liquidation expenses are going to be able to be recovered from the assets before the claimants are paid. Assets. Generally the Department of Ag or other agency that is the regulatory agency is going to look at traditional concepts of lien priority or payment priority in terms of distributing the assets to creditors and claimants, and there may be court approval that is required in this process. Okay, so with regard to, there is a distinction in these statutes as to whether they are going to have bonding requirements or an indemnity fund. And most states will pick one or the other, although there are states that utilize both of these approaches. And so we're going to talk about each of them separately, but I think at the outset, just kind of recognizing what is the basic difference between having bonding requirements and having an indemnity fund. And so with bonding, there is a requirement on the grain dealer to purchase a bond, and then if there is default, that bond is drawn upon to pay those farmers who were not paid for their commodity. And so that is something that we're gonna talk about the provisions in each of those, and then we're gonna kind of wrap it up and look at kind of the pros and cons of each of those approaches. But bonding, there's a requirement on the dealer to purchase a bond. And so when you look at the what is the state involvement in this process, with bonding, there's relatively little or relatively limited amount of state involvement in that process. Now, when we look at an indemnity fund, we have a fund that is created and funds that are paid into it to build it up to be used for the purpose of or in the event of a default. So there is a payment. Every time there is a transaction, a commodity transaction, there is a payment that must be made into that fund. And so the question is raised, well, who pays that? Is it the dealer, the purchaser of the commodity? Is it the seller of the commodity? Is it up to the two of them to figure out who is making that payment? But there is a payment that must be made into this fund, and then in the event there is default, there has to be a process to adjudicate how these claims are going to be distributed. So just that, with that basic overview, you can see that if a state utilizes the indemnity fund process, the state's going to be more involved the state has to identify some entity that's going to be more involved in that process, where with bonding, there is some state oversight, but largely it's a matter between the grain dealer that purchases the bond, or it's a matter between the grain dealer who purchases the bond and then someone who's going to make a claim on that bond. Again, states can choose one or the other, or states can utilize both processes. Okay, so with bonding, this is a core function of just about every one of these state statutes. That there's a surety bond, that you have the grain dealer purchases the bond, you have the guarantor is providing the bond, and then normally the state is the obligee of this, that the state is going to be paid out if there is a default. So the state is going to have some type of process or some type of trustee or person to oversee this process in some respects, just to make sure that the payments are being made appropriately. Okay, so what's the amount of the bond? Generally it's in the $5,000 to $25,000 range. Again, this would be on an individual dealer. Normally there's a maximum spelled out in the statute, which can range from 100,000 to $1 million, and normally the amount of the bond is a percentage of what is being purchased by the dealer. And that bond is purchased by the dealer. It is it's then delivered to whoever the regulatory agency is that is identified. If the grain dealer is going to cancel that bond, so if the grain dealer is going to switch from one surety to another, generally the dealer has to provide notice to the regulatory agency, letting them know that that's going to happen, and that this is going to be replaced within a particular amount of time. Okay, there are some states that give exceptions or provide exceptions to where a bond isn't required if there is some other financial resources that are in place. So if there's an irrevocable letter of credit, for example, that might a state might allow that to replace bond. So, from the dealer's perspective, that's probably going to be less expensive to have an irrevocable letter of credit that, but it serves the purpose of making sure that there are going to be funds in place if there is a default. And the second bullet, kind of the same gets at the same issue, that if there are enough assets that the dealer has to exceed the bond requirements, the state may provide that no bond is required. So these are exceptions that might be authorized by a state statute that has a bonding requirement in place. Okay, so what's the back end of this requirement? If payment's not made, then the seller normally has to file a complaint. Normally, it's within 180 days, of default, although that could be changed by statute. And then those funds the bond funds would be paid to the state. The state would then have a process to oversee the distribution. Now, in the event that the bond is not large enough to pay all of the claimants, generally those are going to be distributed pro rata according to the statute. Okay, so that's the bonding process. Indemnity fund, you'll see that this is a smaller universe, kind of that substantial minority of states have an indemnity fund. And so if the state utilizes this process, they're going to have to establish some board, board, corporation, commission, some entity to oversee this fund, or they're going to have to charge an existing entity to do so. And that board, or that, I'll say the board loosely, for this entity that is charged with doing this, they're going to have to determine what the assessments are. And most of these funds are set up that once the fund reaches a certain level, then payments stop. So, the idea is that if we have a fund of a certain size, we feel that that's enough to provide funding for producers if there is a default. So the board determines what is the assessment, what is the cap of the fund, and then on the back end, how do we process claims, investigate, approve any administrative costs. So this is more intensive from the government side than what overseeing the bonding process is. So most of these statutes will have a stated purpose of the fund, pay claimants if there are refunds that are authorized, and to pay the administrative fees. So what is the assessment rate? Normally it's about a penny or two per bushel. Some states will have a value component of that, and then the states are going to have to figure out how to collect that. Normally, it's collected by the dealer. The dealer sends it to the fund. Now, is the dealer going to add it on to the to the price, or excuse me, not add it on? Is the dealer going to subtract it from what they're paid? That's something that the statute may or may not address that. Okay. If a grower, some states will allow a grower to kind of sidestep the indemnity fund. And if they do that, then obviously there's generally going to be some type of process to notify, or there's some public notification that excuse me, if a grower doesn't want to be protected by that, the grower can petition in some states to be outside of the program. And then, if they want to subsequently come back into it, they're going to have to pay that refund plus interest. So, this ultimately, this indemnity fund is to protect the growers. So if you have a grower that says, that's fine, I don't need that protection, some states will allow for that grower to be outside of the process. Okay, what's the size of the assessment? It can be, states have it as low as $250,000 up to 25 million. And as I said earlier, normally if these funds are set up so when you reach that cap amount, nobody has to pay that assessment. And then if there would be some payouts, then the assessment may start again. Okay, then how are claims filed? Producer has to have some evidence. There's a time period, normally shorter than with the bonding, to make a claim, and then that regulatory agency is going to publish a notice, have some type of notice and hearing process with the dealer before an adjudication is made. And then the claims are paid at a rate. If the fund is large enough to pay, then it should be designed so that it is. So these claims are paid out at a fairly high rate. Now this is kind of after, or kind of a, maybe not a parallel process, but a companion process, that when the indemnity fund pays out, that frequently is established as it's a debt against the dealer. So the indemnity fund, in theory, can pursue the dealer through some type of collection action to recover those funds. And some states consider that the failure to repay those funds as a criminal offense. So the indemnity fund doesn't necessarily take there may be further actions that are taken against that dealer as a result of their non-payment, which requires the indemnity fund to step in to make those payments. Okay, so if we kind of compare bonding versus indemnity fund, and you look at it from the state standpoint as well as from the dealer standpoint, with bonding, we're really putting that direct financial burden on the dealer because they are the ones that have to procure the bond. The state has some oversight role, but much less than an indemnity fund. You look at the indemnity fund, it's easier to shift those costs to the producer. But there is an ability for the producers to opt out, whether that's from a big kind of a high level view, whether that's good or not, I think is another question. But it does require more state infrastructure to operate. But if you're in a state that hasn't had a lot of problems for a while and you can build up sufficient reserves, then there's no need to have a continuing obligation, which in a state that has bonding, that grain dealer is going to always have to be paying for that bond, whether or not there is a history of issues in that state. So pros and cons for both of those. And this is a little bit dated, but it gives you a kind of a visual of how states approach indemnity versus bonding. And you'll see of the states that are listed here, the majority have bonding with no indemnity. Then the next largest group has the next largest group has both. Has indemnity, or excuse me, has bonding, but also has indemnity. And then there's the smallest group has both. Okay. Have 10 minutes left, about 10 more slides, so we should be in good shape and have a little bit of time for questions. Okay, so statutory liens, there are 10 plus, so a substantial minority or a significant minority specifically provide for statutory liens in the grain statute. So again, looking at the federal statutes, the Perishable Agricultural Commodities Act for fruits and vegetables, the Packers and Stockyards Act for livestock and poultry, they provide for those statutes provide for essentially provide for statutory liens, and these these state statutes often provide for automatic attachment. So when grain is provided or is transferred, there is going to be a lien that continues in the proceeds of that sale. There are, states may require certain documentation before that attachment occurs, but there is at least some vehicle that the producer can be protected by having a statutory lien. And generally, the states that have this provision, this is a first priority. So it takes priority over other secured security interests. Okay, penalties. Virtually every state provides for civil and criminal penalties. There is a provision in most for injunctions or cease and desist orders. So this is giving the regulatory agency a fair amount of authority when there is a violation, and so this helps to limit those impacts, helps to kind of take some of the actors that are having financial issues kind of out of removing them from the industry, at least on a temporary basis at least. Some states do require that there be judicial involvement before cease and desist authority is utilized. What can cause penalties if you don't have a license? You don't cooperate with inspections or investigations, make false statements, commit fraud, and most of those, there's monetary fines as well as the suspension and revocation of the licensure. And so this is an area where licensure it can be pretty powerful, because if you have a licensure requirement and there's a violation, you pull the licensure. Well, now you've put that actor out of business. So it can be a pretty powerful tool. And the civil fines, can be, especially if you have an ongoing violation, those fines can be pretty significant. There also can be criminal sanctions. So misdemeanors or felonies, depending on the actions that are taken and the amounts that are involved. There is the typical measures of due process where you have kind of varying procedures, but generally there's going to be some type of notice and hearing before there are civil penalties, and where criminal penalties are authorized, that obviously you're going to have to go through the judicial process to implement those. Okay, I mentioned earlier that Pennsylvania did not have a grain dealer statutes. In past legislative sessions, there have been measures introduced, but they have not gone beyond committee, and these are some of the, at least for these three particular pieces of legislation. You can see that it was really focused on the traditional grain crops: corn, soy, wheat, barley. It provided for licensing and regulatory regulation. It did create an indemnity fund as well. But in a search that I just made recently, I didn't see that anything was pending in the current legislative session. Also, just a word about the U.S. Warehouse Act. We've talked about state statutes today, but there is a federal statute, the U.S. Warehouse Act, that governs or that is kind of in this area. It's a voluntary program. So a grain warehouse on a voluntary basis can go through and get certified by USDA. And so, you ask, why in the world would someone voluntarily agree to be regulated? Well, it may be something that is attractive to customers, or some customers may require to get that protection. But it is, this is at least some level of regulation at the federal level, but it is voluntary. Okay, just in the last couple minutes, just to highlight some specific references. I already mentioned the National Ag Law Center's website. They have a fairly recent publication that provides some updates to grain indemnity provisions. And then also, this is an older article, 1982, but this really provides a pretty good overview of the, looking at it from that time period. Rich really was at the kind of in the farm crisis of the 1980s, and provides a pretty good early overview of this topic. Also, the Farmers Legal Action Group has a good guide, and then I've also included the link to the U.S. Warehouse Act here as well for your reference. So, and then finally our reference, the Grain Dealer Regulatory Compendium, and as I mentioned, we have some other work in this area ongoing that we'll be updating pretty soon. So
thank you everyone for joining us. Our next program will actually be the quarterly dairy legal webinar series. That's on October 14th. We do have the AgWorks webinar next week on September 30th, but that is not for attorney CLE. That's part of that producer-oriented AgWorks program. And then under this Understanding Ag Law, next month, October 31st, will be Jacob Monty from Monty and Ramirez talking about immigration compliance, I-9s, audits, and ICE rates. So have a great weekend, and we'll hope to see you next month, next week, or at some point in the future. Bye, everyone.